We'll formally start. Welcome everybody to this edition of the HRUG-Open Human Rights Universal Global Open seminar, taking place on the last Friday of most months at this time. We have a series of invited speakers on a range of topics broadly in relation to human rights. And legal and social implications, foundations, ramifications. Today we're very pleased to have Shenfei Zhou, a PhD candidate at the Human Rights Center of Central South University, Changsha in China. And Shenfei is going to talk to us principally about her time at the Office of the High Commissioner for Human Rights, and discourse eruditely about that and possibly some other things as well. So just to let everybody know, this is being recorded. So I will hand over the floor to Shenfei. Shenfei, you're very welcome.
Thank you very much. Let me share my screen. Wait a minute. Can you see my screen clearly?
Yes, thank you.
Works.
Okay, perfect. So thank you again, and good afternoon, good evening, everyone. I'm very honored to have this opportunity to share my experiences and some of my reflections today. So let me begin with why I choose this topic. As my initial background is in international law, I was trained to look at legal texts, rules, obligations, and so on. From this perspective, like human rights mechanisms are often studied through questions such as what is their legal basis? Are they created by the charter, by treaties, or something else? And are their outputs legally binding, and in what sense? These are important questions, and this area of research has achieved notable successes. For example, treaty bodies' general comments are now widely regarded as treaty interpretations of human rights conventions and have been cited by the International Court of Justice. But through a year of studying global governance, I became more interested in another question: how do human rights mechanisms actually operate in practice, not before the courts, but in real life? This question seems particularly urgent today because we are living through a period of growing pressure on multilateral institutions. So that's why I choose to be an intern in this office and also choose the title today, Behind the Papers, Human Rights Work in Time of Crisis. I'm not be offering perfect answers to these questions today. Rather, I will share some of my concrete examples and perspectives to contribute to broader discussions around this topic. I will first go with 3 examples from my internship at UN Human Rights, then move to broader reflections on how human rights mechanisms operate in practice and in time of crisis. Let me briefly introduce the office I worked in, the Office of the High Commissioner for Human Rights, OHCHR. My colleagues usually pronounce it as OCHR. Our boss is Mr. Volker Turk. He's the High Commissioner, HC. I did not actually work directly under him because he's in the headquarters, which is in Geneva and also New York. I'm actually working in a regional office. It's called the Regional Office for Europe, ROE. My colleagues pronounce it as RO. So as you may already have noticed, there are a lot of abbreviations within the UN system. And I often felt that I was reading another language, especially for the first and second month in the office. There are easy ones like HC, High Commissioner, DHC, Deputy High Commissioner, but there are harder ones. For example, the Global Operation Division, it does not select the letter of the words, but it's just use another abbreviation, because if you select the first letter, it would be JOD. It makes no sense. And for example, the other one, list of issues prior to the reporting, the LOIPR, it is actually a very, very small thing, but very significant thing. It is within the treaty body's task. It is actually a very significant step before the treaty bodies are making the concluding observations to the specific state. So we also have a abbreviation for this step. So from this, actually, I already have a very early observation feeling that to work inside a human rights mechanism is not only to know the human rights knowledge well, it is also to learn how the institution speaks and works. The role office, the regional office I work, is part of the HRUG field presence system. And the HRUG is actually like within the broader landscape, it's a department of the UN Secretariat. So generally, there are two types of human rights mechanism. One is called treaty-based mechanism, and the other is charter-based mechanism. And the HRUG office is actually provides expertise and support to all of them, like all of their works. So as you can see from this map, the HRUG contains, the HRUG itself is a very big family because it contains 2 headquarters and 90 field presences. So my office, the role office, is one of the field presences. It's in the right circle here. As it is a relatively small office with only 15 persons. So I had the opportunity to be involved in a wide range of areas like rule of law, civic space, migration, business, human rights, economic and social rights, capacity building, communications, and so on. So from there, I'm very lucky to have my first task, which is contribution to the EU rule of law report. And for your background, that the EU, every year they publish the rule of law reports that covering the rule of law situation over 27 EU member states and selected candidate states. So our task is actually contribute to that rule of law report with human rights recommendations and observations from the main human rights mechanisms, to organize them in a way that could fit in the framework of the EU's rule of law report. Because apparently, and it's also the most interesting part I found, is that the human rights information could not simply enter the EU rule of law framework as it was. It had to be selected and reformatted because the EU rule of law reports have their own categories, like 4 pillars: justice system, anti-corruption, media freedom, checks and balance. But human rights materials are much more broader, and they don't adopt these 4 pillars. And even under the same topic, for example, the justice system, according to the EU's list of topics, the justice system refers more to the independence and resources of the justice system. But for the human rights mechanism, that for the UN, the human rights materials we applied on, it's also including the child justice, which is the children's rights before court, and also a holistic approach of transitional justice, and so on. So this part actually need to be cut down from the contribution to the EU rule of law reports because they are not actually fit into the 4 pillars. So this is actually one reflection of behind the papers. So behind the final documents, there's often a long process of fitting, translating, and sometimes compromising like this. But at least some of the human rights language is involved and submitted, and there were still some flexibility and space to push. For example, my colleagues using titles called special theme to actually attach some, to capture some recurring human rights concerns that could not be fit in the framework, but are more or less related to the 4 pillars. So there is always some small space to push if there is someone who want to push. And the next case regarding the business and human rights, especially in the context of EU omnibus packages. So the background was the EU's policy simplification agenda. So since early 2025, there have been proposals coming out about reducing administrative burdens and improving business competitiveness. But these discussions also affect areas that are highly relevant to human rights due diligence. For example, they are cutting down some articles and also adjusting the range of articles in the CSDDD, the Corporate Sustainable Due Diligence Directive, and the CSRD, the Corporate Sustainability Reporting Directive. Both of them are highly relevant to the human rights due diligence. So in this case, our work actually is following this fast-moving policy development and preparing analysis, launching events, roundtables, publish press release, and also reports, engaging with different actors. So what I found interesting was that the human rights work is not actually similar to my imagination that reacting after the policy had already been adopted. It was also about intervening during the policy process. So when the dominant language becomes the competitiveness and the simplification, our work is to keep human rights standards in the conversation to show why due diligence matters and why accountability matters and why this or that articles are related to them and why simplification should not mean weakening the protection of human rights. So there's also another thing that's even more interesting, that during one of the roundtables with the companies, that I found out that the companies actually were among those against the simplification because they have already completed the human rights due diligence requirements under CSDDD and CSRD. And they found that the omnibus packages actually increased their cost to explain to their clients and creating new uncertainty. So that's a very, very interesting thing. So from this case behind the papers, I found the human rights work is more like agenda maintenance in the real time. And it involves that identifying risks, supporting dialogues, creating spaces where different actors can sit down and discuss the human rights implications together. So what about the time of crisis, the huge context of this conversation? I think there are at least 2 crises that need to mention. One is political crisis, and the other is financial crisis facing by the UN mostly. The first one, I'm speaking from the human rights mechanism perspective, so maybe there are a lot of others, but I don't include in this presentation in this page. So from the political perspective, there are recent news that state withdrawing the Human Rights Council, they are not cooperate with the Universal Periodic Review. They don't actually join this game anymore. So here comes the question that does it create a real problem of legitimacy? Actually, if we're looking at from the procedural rules, it actually takes time to see like whether or not it creates a real problem, because from the UPR's procedural rule, if one state actually express non-cooperation with UPR, the review would be automatically suspended, and wait until the end of cycle to see that whether or not if this state would accept the UPR review or not. So it would be till the end of 2027 to know if the US will be back to the Human Rights Council or not, and to see whether or not this kind of thing would destroy the system of Human Rights Council. But till now, I don't think it's a very big issue. But for the financial side, the financial crisis is actually more hurtful because we see that a lot of funding cuts, and the funding cuts actually resulting in the cuts of posts. So we have seen also it's a more complicated situation that the funding cuts affect some regions more severely than the others. For example, some offices from Latin Americas are cut entirely. I'm saying the OCHA offices, the field presence offices, and most of their work are shifted to the colleagues, remained to the consultants, to the volunteers, or other forms of with an unstable contract. However, recently, a new regional office was established in Vienna to work on human rights issues more specifically with European countries. That's why my office that I used to work in is called ROE, ROE, and now changed its name into representation office to the EU, which is ROEU, because there's another office established to concentrate on state works. So actually that's kind of make me ask that if these kind of things representing that human rights work is becoming more Eurocentric, I don't know the answer. But of course, this kind of financial crisis does not impact the conditions for interns in this office, like me, because we are unpaid in any ways. I remember I had a conversation with the special rapporteur on contemporary forms of slavery about whether unpaid internships in the UN Secretariat could be understood as his working area. And he said not directly, but yes. I do not want to overstate this conversation, but it points to some real tension behind that. Well, the human rights mechanisms promote universal values. The mechanism itself needs to be supervised under the international human rights law, especially under the situation of funding cuts. And after looking at all these examples and understanding the crisis, I came to conclusions of what I learned behind the papers. First, I learned to see paper making as process. The point is not to treat papers as final products, but to look at how they are made. The making of documents can reveal how human rights knowledge is organized and made usable. And then find out the work through the paper is kind of translation from real reality to UN reality, linking field knowledge and UN discourse, traveling from particular and universal. They are able to make the context and the content of human rights in the real time. And finally, I saw non-normative values from this experience, as human rights mechanisms do not only matter through binding norms or immediate state compliance, they also keep unfinished issues visible, create institutional memory, connect actors, and sustain a universal vision of world order. So I think it's worth looking behind the papers to find out more realistic values of this human rights work. And this concludes my opinion of this presentation, and I look forward to listen to your opinion of these broader issues, and if there's any question regarding my specific cases. Thank you.
Thanks very much, Shenfei. That was Shenfei Zhou, PhD candidate at the Human Rights Centre of Central South University in Changsha. A very interesting behind the scenes, as it were, look at the work of the OHCHR. Now I'm using the acronyms. It's infectious. I won't be able to stop. So very much for that, and I am going to throw the discussion open, or throw the issue open to the floor for discussion, I should say. So please, Mehmet, are you raising your hand? No.
Yes, I wanted to ask something to Shenfei. I mean, a general thing. Shenfei, thank you for your presentation. When we speak of crisis of the human rights procedures or practices or whatever, or even discourse, do you think that nowadays it is something systematic? First, this is the first question. And do you think that one of the main problems is the legal protection, the collapse maybe of legal protection issues? I mean, the access to legal protection, to advocates, to advisory institutional frameworks, etc. Do you think that this is something systematic nowadays, even planned made?
I would say thank you for your questions. I would say that through my experience in Brussels and also my ongoing reading of the literature, I just find one thing that I can understand that's as a systematic issue maybe is that international law nowadays we need to actually think its value under a lot of crises, because I feel like international law itself, it can no longer answer a lot of questions because we see like a lot of for example violations nowadays and a lot of different state interests that could not actually be discussed under a multilateral platform. And there's even a new thing that's called I don't know, created by a president. It's called Board of Peace. Such a thing like that could be established and created within today's world. So I do think there's something that's systematic happening nowadays. But because from my perspective, it means that we could not actually look only into the international law, and we cannot to always imagine a utopia and to stick on the universal kind of value, but we need to move our perspective and move our views into field works and also the process of achieving that kind of goals. That's what I think maybe it's useful for nowadays. And for the legal protection things and also for other advocacy initiatives, I think they are both very important, but I don't think that it's a very leading problem now. I think the leading problem is that how we see the international system under this kind of global crisis, and also from the human rights perspective, are the state-centric perspective of realizing human rights law is the correct way for the future. I thought that, and I think that should be revised and think deeply.
Thank you.
Okay, Peter has his hand up.
Yeah, thanks. Very technical question first. Who gets actually into the position? Are they elected? Are they nominated first? And. The other thing is a more complicated question, actually linking to what Mehmet said before, or asked before, the crisis. From my experience, having worked in the context of European Union, here it's probably multiplied. This complexity of an institutional net isn't that a crisis as such, because if you look at the different rights, if you look at adjustable rights, absolute rights, those who are really, you mentioned housing, access to housing, who is able actually to claim these rights without a solicitor, without experts, without a lobby organization behind them, to say, I have to go through this. I know this is my right, but whom can I address if I don't have the means as individual being concerned? So in the way, there's this complexity of institutions, and somebody there, somebody sitting in Geneva, somebody sitting in New York, and then somebody sitting in Brussels, how to deal with this in practice.
So there's two questions. For the first question, are they being nominated or selected? Do you mean the head of the office or all of the colleagues that working in the office?
Well, it's basically concerning all these positions. Well, if the political positions, let's say this way.
Okay, so I think for the political positions, they're actually nominated by the states mostly, but the nomination are submitted to the Human Rights Council. For example, for example, I would give an example on the special procedures, which is under the charter-based mechanism. The mandate holders are nominated, and even their mandate are established by the states. But the people that are actually be selected into that mandate, it should be through a process. It's called HRC, the Human Rights Council resolutions. This process is actually need to go over like 1/2 of the votes from the states. So it's kind of how to say? I would say this process is actually very political contested, and but after that, after the mandate holders are taking the mandate, it's something that happens a little bit different. It turns not so that political, because I sometimes, like when I'm working in this office, I encountered several mandate holders and heard from their opinion that they actually listen more to the non-state actors and listen to the people. And that's where, like you mentioned in the second questions, that the individuals where they could go like for expressing their needs on the human rights, for example, the right to housing. So actually the mandate holders are taking a lot of different views from the non-state actors, the social society, and listen directly to the people, and then gather the information into organized documents, then submitted to the Human Rights Council, and also through a way of being applied into the general comments of another treaty-based, another human rights mechanism, and to be as a treaty interpretation of human rights convention. So it's a process. I can see, like, even though they are nominated and selected by the states, and even the mandate is created by the states, but they still can have a lot of things to do during this process, and to make the idea of the people and also the non-state actors through this process like into the formal documents, and also have another like non-normative if non-normative values. And for the second question, so within the human rights mechanism, except from the I was saying the special procedures, they can listen to the individuals. There's also individual complaints that some kind of quasi-judicial structure under the treaty bodies, so they can actually hear the calls and also the applications from the individuals. So individuals, if they think their rights are being infringed, so they can apply a case actually before the treaty body systems, though, so they can just apply all of the interpretations of the international human rights law according to that case. And nowadays that the quasi-judicial structure are getting more and more attention like within the system, not only the international law legal scholarship, but also the international relations and others. Yeah, that's my answer.
Thank you. And Mehmet has another question. Mehmet, you're on mute.
Okay. Shenfei, I will ask you a question which makes me sometimes hopeless a little bit and even pessimistic about the future of human rights. And this is the topic which I would say enforcement of legal decisions. On the one side, some decisions have to be enforced, they have to be practiced, they have to be put into a certain practice on the one side, which is theoretically not bad. Huh? But on the other side, this seems to be a sort of contradiction, because now we have again what we call power politics. That means, I mean, for you, is this not a categorical thing? Can even say a contradiction which can be hardly be solved. Huh? This is my question. What do you think about this tension between the need for enforcement of decisions and the possible outcomes if this would really happen, huh? The negative outcomes of this? What do you think? Thank you.
Thank you. That's a very interesting question. And I've been thinking that question for a long time. And that's why I kind of turn into non-normative effective instead of only looking at the legal effect, because I think that's cannot speaking about a lot of things. On the surface, that the legal decisions may be not applied and go into the enforcement stages, but actually the state will feel pressure like after receiving such decisions, and also they are facing pressure very directly when they are submitting their state reports to the treaty bodies. So they're having a concluding observations. So in the meeting, the people like on the desk will actually asking and actually taking that's all of the individual cases together. Like that's one kind of pressure. I would call it like diplomatic kind of pressure. And if that is happening once, it's only diplomatic pressure and it's only diplomatic effective. But it's happening again and again, that every 2 to 3 months, it happens to like the states will submit their state reports and go into the meeting. I feel like that makes difference, because I see that if we see that it's from the micro level perspective, so it's actually a lot of experts and also officials worked in the states are gathered in the meeting, and they worked for different institutions, but they have the same background and they have the same understanding of the human rights law. So after 1 year and 1 year's meeting and also repeating this kind of how to say, like this kind of thing, so they would actually move this things into forward, because yeah, I have seen literature that's using anthropologists view, like to observe like these kind of things happening like in their everyday practices. So I would say that maybe from the international legal perspective, it does not happen and it does not make any sense because the decisions are decisions, but there's no enforcement, and this kind of things is happening for last 80 years since the establishment of the United Nations. But now I think maybe we need to change another point of view, that from the macro level, that all of the interpretive community, all of the community of practice, and all of the community of knowledge are actually working based on the legal decisions and move forward to the next step. So I think maybe that should be a point of view of the future of what we see in this such of things. And I think we will have some hope there, and it's not a time that we are hopeless and we still got something to do.
Okay, thank you. Before I
Thank
see
you.
Peter's hand up, before I invite Peter back in, can I just check, Shenfei, if either of your colleagues in Changsha who have joined us have any questions to put to you? Don't be shy. No questions from your colleagues. They understand you perfectly, it seems.
Perhaps if you have
Yes.
questions, you can ask in Chinese, and Shenfei translates both the question and
Yes, they can
the
ask
answer.
me like after this meeting anyway.
Okay, Peter, you have your hand up.
Yeah, there is actually one thing linking to what the last point, diplomatic power questions, and then I think what may be hugely relevant there is if I look at the global operations, GLO, and these things, where you have simply political officials, political administrators or something, they do the job and are not really or not directly linked to political issues, but they are just executing what they are told, what they have to do, and what their opinion is. This is the one thing. The other thing is a little bit cynical, or probably very cynical, on what you said before, quoting a famous colleague, Mr. Keynes, economist, in the long run, we are all dead. And if I look at the different stages to claim my human right in case of that it's not recognized, that it's not acknowledged, or that the conditions are not there, that takes such a long time. If I look at this process, yeah, that in the long time I'm dead, and the negotiations are going on. Would you see a way there of speeding up this process, of making it directly accessible?
Thank you for your question, but I'm not sure I understand the first one. It's something related to the officials that are not doing their jobs well.
No, it's not that they are not doing the job well, but you have the difference between, on the one hand, you have the political positions, the explicitly political positions.
Yeah.
On the other hand, you have, I know in institutional terms, one of the institutions that is actually not known, it's the COREPER, which is the Committee of Permanent Representatives of the nation states. They are, between the meetings, they are actually working out compromises and negotiating things. They don't have explicit political power, but at the same time, they are hugely involved in political processes. So this may be part of this tension Mehmet mentioned. And in Europe, in the European institutional system, they did not find a solution to this, and that's why I'm afraid that's part of the crisis of the permanent crisis, ongoing and reoccurring crisis of the European Union. And now we see the same with the United Nations, that states withdraw and that they're unhappy, they don't pay, and. So this is simply one more comment, really, to.
So I was about to say it's more comment than a question, perhaps.
Yeah. And the other was really a question of do you see or somebody else sees a way of speeding up processes?
Yes, I understand now, and I kind of agree, like your opinion, and I think I also have seen this tension, like between the person that have different like roles in their own, and also another tension, if I may express, that during like I'm experiencing all of this, like in regional office for Europe, I noticed that in this system, a lot of the officials are not representing global source. Can I say that? Because for example, in the treaty bodies, like all of the all of the experts are, I think, 90% from global north. And they, of course, they are very professional because they occupies the knowledge of this area, and you cannot find another one that could be could be listed as like better person than him or her. But it's also something that the kind of knowledge is actually distributing kind of power again, like in the like normative level, and also during this process, because because the knowledge is actually occupying this body, and you can't even have the entry points to actually open it and to open it to another, maybe to build another like branding new institution inside it or branding new idea inside it is kind of impossible. And the only thing that you can do is to build on the institution that we have now. And the second one, like how to speeding up this process, I would say maybe give more confidence to our mechanisms and to have more human rights education like towards all of the population, because once we are speaking of this human rights language and we are letting a lot of different things could be involved in this language, that we are actually speeding up this process, because it's kind of like the water of consensus are getting higher and higher, and when like reaching such points that every people that's from diverse background, they actually reached a kind of consensus through whatever constructive dialogue or any other like conversations, communications, or community of practices. They will more, how to say, like more like they would like more likely to agree with kind of to recognizing such human rights, and they are more likely to build on the human rights work. So that's the only thing that I can think about like now.
Very good. Thank you, Shenfei, for answering all those quite difficult questions in some instances. And again, unless Shenfei, your colleagues in Changsha have any contribution to make, this is your last chance. No. And unless Peter or Mehmet have some concluding comments. And just to check, you had some interesting references at the end of your, Shenfei, you had some interesting references at the end of your slide. Well, when you're posting that slide, will you post those slides on our HRUG website? And could you
yeah, maybe
send them to Peter? Peter, is that okay?
Yeah.
And with the references, with the full bibliography, if you like, the Merry and the Naples Mitchell references in particular, I'd be interested in hearing more about that. And Peter, you have your hand up.
Yeah, I have actually a little bit awkward question, not to you, Shenfei, or to Joe or Mehmet, but to the other silent audience. What do you actually, would you mind to say what you expect studying in this area, how to, what it means finally to get into the, what is your expectation there? And to Shenfei in a way as well, because you are still studying, where do you want to go with it?
Honestly, I don't know, but I want to maybe establish another perspective of researching on the human rights areas, because I think I've been working too long like on the legal sides, and I find out like I cannot answer something, so maybe I will more dive into some micro perspective and watch more like how to move a step forward in everyday practice, and not only seeing that the huge thing that a very, very big judicial decision has been passed, and adversary opinion like from the International Court of Justice are actually published, and any like codings inside. I think in the future I will not. I will concentrate on. I will also consider the all of those things, but I think my interest that shift into the macro level are more about the society and law and society, also, and also the political sides within all of the international system, and to see that how to move forward from this micro perspective, like in this area. I think it's my expectation of my future work. Maybe I'm still working on a research idea on the special procedures. It's also from the insight perspective, and also use some anthropological methodology, maybe like to move forward on that proposal. But I'm still revising, so I'm not presenting that today. So maybe in the future.
And on that note, I will wrap up today's proceedings. This has been the another edition of the HRUG-Open Human Rights Universal Global, Friday, the 29th of May, 2026. This is Joe Finnerty from University College Cork in Ireland. Thanks to all who tuned in, including our silent audience in Changsha. But of course, a big thanks to our presenter today, Shenfei Zhou, for a very interesting discussion on human rights and behind the scenes of human rights. So thank you very much, Shenfei. Thank you all for attending. See you next time.
Thank you. See you next time.
Thank you. Bye-bye.
Thank you. Thank you.